it's the last meeting. Let me thank all of you for putting up with us all year. I think we've done really good work. My appreciation to the committee and their time and effort. We've had some very lengthy issues. And as always, Andy Hedges from LSA. Andy, you do a great job. You are the best of the best. And I always appreciate your help and everything you do and answering my phone calls late at night. So thank you for that. We are going to work on 1338 this morning. Would you like to introduce your bill?
Thank you, Mr. Chairman and members of the committee. 1338 is a bill on, the main part of the bill is on rules of decorum for local government meetings. So in my area, and really it's happened all around the state and in different parts of the country as well, but I've had some experience in my locals have had some experience where there have been some individuals have been showing up at our government meetings locally, just being extremely disruptive, causing issues. When our locals tried to adopt the rules of decorum and enforce it, there was some hesitation by law enforcement on how to handle that, how to go about removing. So there's no clear-cut statute and law. So I worked with Association of Counties, AIM, the Public Access Council, and others to come up with this bill. And really all it does is it says that a local unit of government can adopt a set of rules of decorum. And then I went by the 3 strikes you're out approach. We don't dictate what the rules of decorum are in here. We let the local units of government decide that. Obviously, they have to take into account First Amendment rights. They can't do anything that would violate the First Amendment. But once those rules of decorum are established, before a public meeting, they would notify the public of those rules before public comment could take place. If somebody does get out of order, we went by the 3 strikes you're out approach. There'd be 2 warnings. Then upon the 3rd warning, if the individual is still not in order, they could be asked to leave. If they refuse to leave at that point, then law enforcement could remove them upon the direction of the presiding officer. Nothing in this bill would prohibit law enforcement to removing somebody immediately if there's somebody that's committing a criminal act or that law enforcement would have additional reasons to remove them under current law. And then also the code side on page 2, line 31, that is our tort claims law, or essentially our version of qualified immunity for our law enforcement and public employees for following this chapter. And then the second section of the bill, the original language that we had in committee, it was narrowly focused to if somebody would trespass inside of a public building, but we did open that up to all property. So if somebody enters or refuses to leave an area of property that's marked restricted, or employee or personnel only, or goes beyond a locked door, then they could be hit with trespass. And the reason we changed that in committee was due to the Young versus State of Indiana appellate court decision from last year. So we tried to fix that court case, or fix the language that in our trespass code based off that court opinion, which essentially the courts ask for a legislative fix towards the end of their summary. With that, I did also want to mention that in the House, we had the mayor of Winchester came and testified in support of the bill. AIM, Association of Counties, Public Access Counselor. Bill passed with bipartisan support, and I appreciate your consideration. I'll take any questions.
Questions for Representative Prescott? Senator Brown.
Thank you, Mr. Chairman. Thank you, Representative Prescott. I guess I'm just wondering, can't the governing bodies do this now?
So they can adopt rules of decorum now, and everything that they would be acting on is based on court opinion, opinions from our public access counselor, which the public access counselor's opinions are just that, opinions, right? They don't carry the weight of law. So it's just his opinions that they're going off of. The problem is really on the enforcement side. There's nothing in current Indiana law that during a local meeting that would allow for the local units of government to have somebody removed if they violate those rules of decorum. So it's the enforcement piece is what the struggle is.
Well, okay, so if the rules of decorum say you can't wear offensive T-shirts, then that might be an issue, right? But if I served on city council. We had officers, I think almost all the time when we had a hearing. Public was instructed when they could speak and when they couldn't, et cetera, the public comment time, et cetera. I just don't understand with our current public nuisance or creating a disturbance, et cetera, laws, why you can't just use those now.
I would refer back to my conversations with our local law enforcement, and what they were telling me is they were really just fearful of a lawsuit themselves. So they wanted something in Indiana code that would give them some protection from a lawsuit. And as you know, I mean, people can sue for any reason. That doesn't mean they're going to win. But that is the genesis and the reason that I brought this bill forward is to try and give some clear guidelines as to how to enforce those rules of decorum, and also to make sure that it's clear on what that process is to remove them. So I think this is I was trying to find a balance to make sure that we're protecting everybody's First Amendment rights, but make sure that it's a clear-cut process.
All right, thank you.
Do we have other questions about members of the community?
Yeah, one more. Thank you, Madam Chairwoman. So Senate Bill 293 already deals with the trespass issue, and that's already been through the House. Are these going to conflict? Because it looks like the one that came through the House looks significantly different than what you have. And if so, can we just delete that part of the bill on a second reading amendment?
I believe there may be some conflicting language that we may need to work through, and I think you have an amendment to address that.
Okay.
Or Senator Freeman has an amendment to address that.
Thanks.
We have a new member of our committee, by the way. Devin is here, and lovely Nikki Gray's daughter. So another great LSA attorney. And welcome to the committee. You're a phenomenal upgrade, in addition to this committee. All right. So, all right. Senator Pohl.
Thank you, Mr. Chair. So Representative Prescott, you had said that there were clear guidelines, but I think reasonable minds can probably differ on what is disruptive. You may have somebody that continuously asks the same question because they're not getting a very clear answer from a board member, council member, and that could be seen as disruptive. But there isn't anything that it defines what necessarily disruptive is in your bill. Is that right?
That's correct.
So, I mean, do you see that there's a potential First Amendment issue here with the bill the way that it's drafted, where it's just leaving it as disruptive as opposed to, specifically stating what type of behavior?
No, I don't. I anticipate that our local units of government are going to work with their city and county attorneys respectively. I see it no different as to how we conduct business here in the General Assembly during committee hearings, where there's at times where, or even in the House or the Senate chambers, when there's individuals that get disruptive and need to be removed. So no, I do not anticipate any issues coming up from that.
So for example, like who makes the determination ultimately? What is disruptive and what's not?
So I have in the bill that the presiding officer would make the determination to give that verbal warning. Same thing as how we do it in the House chamber. There was a bill in the first half where there was somebody that got disruptive on our side and had to be asked to quiet down. They didn't quiet down, and then they were asked to remove. So it's no different than the process that we have here.
But there is nothing in your bill requires any of those presiding officers to go through any type of training or any type of, so for example, like a police officer, they make the determination when a crime is committed, correct? And when they can make an arrest based on probable cause, they go through training of that. There's nothing in your bill that is going to require any presiding officers to make that determination, what's disruptive and what's not. So potentially you could have somebody that's abusing what they deem as somebody who may just have a different opinion than they do on an issue, or may be passionate about an issue, and would subject that person to arrest simply for silencing that position. And there's no training that's going to be provided to the presiding officer, whether or not what they're doing is correct. I mean, they could just potentially throw somebody in jail.
So I would say that on the training side, there's no training that's required for our Senate Pro Tem or the Speaker of the House in that regards either. And they have the ability to remove somebody that's being disruptive. So I don't see it any different there. And then also on the protections from the local units of government cannot violate the individual's First Amendment right. So if it gets to where it's going to violate the First Amendment right, they do have a lawsuit on it. Okay, so I trust the judicial system to take that under consideration.
I trust the judicial system very much too. So thank you.
So there are 4 amendments. So I want to get through the amendments. All right. So let's do the amendments. So let's do them in reverse order. So amendment number 7, What Amendment 7 would do is would require that the public access counselor, when he or she is issuing their advisory opinions, that they are going to consider only the plain text of the public access laws and valid Indiana court opinions. Is there questions about Amendment number 7? Is there a second? Can we take it by consent? Okay. Andy, you're going to call the roll on Amendment number 7.
We have discussion.
Yep. Is there a comment or discussion?
I have a question about this. What is this suggesting? And I don't know. That's why I'm asking. What is the public access counselor allowed to consider now? And so I assume with this amendment, we're saying you can only consider public access laws as plain written and valid opinions.
The public access counselor, when issuing an opinion, current law says that opinion they are to liberally and look at the code and reach a decision. So this would strike that language and say, no, the public access counselor is confined to the plain text of our code and valid Indiana court opinions. So it is a statutory construction question. And this would change the law in statutory construction, what they're able to consider.
Okay, so if there is law, federal law, for example, that might be applicable, they cannot consider it then.
No, they can. It's just Senator
It
Brown.
says they shall only consider public access laws as written and valid opinions of Indiana courts.
Well, first of all, let me back up. I don't know if the public access counselor is going to be asked to weigh in something that's federal. I mean, it's a state code issue, right? So when asked to give an opinion, they're going to consider the Indiana code and our Court of Appeals and Supreme Court cases. And the point is that they're limited to the text of those two bodies of work. All right, so any other, Senator Pohl?
Is there something that we're specifically trying to exempt or keep out of the purview of the public access counselor with this amendment? I mean, we're talking about, public law, access laws is plainly written, but not any other laws that have been written in the Indiana code. We're talking about
Senator Pohl, I love Amendment number 6, by the way, which would say that broader than the public access counselor, we should only consider the plain text and valid court opinions. There are some that believed that went too far and was too much of a swing for what this bill would do. So Amendment 7 simply restricts it to the public access counselor. I would love to do Amendment number 6, by the way, but that was seen as maybe going a little bit too far.
Well, I mean, to my first question, though, what are we trying to exempt here? What are we trying?
We're not trying to exempt anything.
Or what are we trying to
Nothing.
exclude? I should say.
We're not excluding anything. All we're saying is the public access counselor, when he issues opinions, all we're saying is, as opposed to liberally interpreting the code, he shall confine himself to the plain language of the code and to the Court of Appeals and Supreme Court cases. That's all. Nothing more, nothing less. That's as simple as it is.
So when the plain language is ambiguous, though, he's not allowed to look at potentially any other secondary sources, any other
Doesn't say that.
logic or reason or anything like that.
Doesn't say that.
Well, if you're saying as plainly written, then it infers that if ambiguous, and looking at the rules of statutory construction, how that's to be defined. I mean, are we simply taking away his ability to make a determination based upon, if there's an instance where there's an ambiguous phrase, an ambiguous word or anything like that?
Just so the record's clear, I completely believe LSA does a great job, and they are always explicitly clear in what the code should say, just so we all know what's going on. To the degree that that's not the case, then the public access counselor is going to confine himself to the text of the code, which is what should happen, and then to the plain text of any Court of Appeals case or Supreme Court case.
Okay.
You good? Senator Glick.
When you do this, your words of limitation now excludes everything. I mean, you're paying an attorney for their opinion, and now you're limiting that. And because it's specifically limited in the amendment, then anything they say above and beyond is going to be considered in violation of the statute. I don't know why you would put that limitation on the attorney that you've hired to represent you.
Senator Glick, I don't know if I agree with you. What it's saying is when someone, and this is no different than Antonin Scalia's book on statutory construction, when a judge in this case is considering what they're looking at, they're going to consider the plain text of the statute and Court of Appeals and Supreme Court cases. It's no more complicated than that. They're not limiting anything to what the litigants are saying in this thing.
Then why are we putting the limitation in the statute?
Well, because right now, I mean, the public access counselor, it says that he, in this case, shall liberally construe the code, which has, I don't think I'm breaking news here. He's issued some opinions that I vehemently disagree with, and I think others in our body and in this building vehemently disagree with.
Okay. Thank you.
Senator Carrasco.
My question was kind of along the same lines of what you just mentioned. Is the reason that you have this language to address the language that's being struck in the amendment portion above? Oh, never mind. I'm looking at the wrong amendment. On Amendment 7. Amendment 6, you've stricken the provisions liberally construed.
So again, Amendment 6 went further than the public access counselor. So Amendment 7 confines it to the public access counselor. I would love to make it more broad, but those that encouraged me to hear this bill felt that went a little too far.
But still within the.
Oh,
All right. Any other questions? Any discussion? Senator Brown.
Thank you. So I just wanted, so for example, ironically, the underlying bill could be construed as impacting free speech. So if now the public access counselor would not be able to consider constitutional law, federal law decisions because it's not a valid opinion of an Indiana court or the public access laws as plainly written. Right?
Senator Brown, they are to consider the plain text of the statute.
Right.
There are those, and look, I am not trying to get us to law school statutory construction class. There are those among us that believe, as Antonin Scalia did, that we are confined to the plain language of the text. There are others that go and, as Senator Pohl mentioned, go to outside sources, other people's constitutions, other governments' constitutions, outside research. What we're saying is the public access counselor should be confined to the plain language of the text, our code, and Court of Appeals and Supreme Court cases.
Right. But that's what I mean. So we're not necessarily saying that our public access laws as plainly written necessarily represent U.S. Supreme Court decisions, for example, on First Amendment rights. We would hope maybe they do, but if they don't, or if the public access counselor reads our public access laws as plainly written as not encompassing, for example, some Supreme Court decision, they can't consider that because that's not going to be in their purview now.
All we're saying is they are to consider the plain language of it, not to invent other things or to consider other things. They are to consider the plain text of the statute and the code.
Right,
and
our
cases.
statute, our Indiana code.
Right.
Right, so they can't consider a U.S. Supreme Court decision, right?
If I may, Mr. Chairman,
Maybe I'm
Please,
confused.
I would love you to.
I would argue that they would be able to because the hierarchy of our Indiana law as it's written in Indiana code is the United States Constitution, the state constitution. So therefore they have they'd have to interpret the federal constitution.
Okay. So any other discussion? All right, there's been a move and second. Andy, will you call the roll on Amendment 7?
Senator Pohl,
Explain my vote.
Quickly, 1 minute.
I completely agree with Senator Brown. I mean, the way as written, it states Indiana courts, the opinions of Indiana courts, the federal cases, Gitlow, Stromberg, the West Virginia Board of Education, like some of the fundamental cases that are decided at the federal level those are federal court opinions. Those are not Indiana court opinions. The way that it's written, I mean, I think it could have been written better if the intent was to include federal case law as well as Indiana case law. The way that the amendment is written, it's seemingly limiting it to public access laws of Indiana and the Indiana courts. So I can't support this. I've got to vote no.
Senator Taylor.
Explain my vote real quick, 30 seconds. There needs to be some clarity. We've got time to do that. Let's fix this on second reading. I'll vote yes for today.
Senator Glick.
No.
Senator Cook.
Aye.
Senator Bohacek. Senator Brown.
No.
Senator Young. Senator Carrasco.
Aye.
Senator Freeman.
Chair votes aye.
5-3.
Passes 5-3. The next amendment is Amendment number 5. No, let's take Amendment 4 first. Amendment 4, what it does is, my understanding is the public access counselor serves for a period of years. This would add a comma and say that the public access counselor then serves at the privilege of the governor. Any conversation, questions about Amendment number 4?
Why?
Is there a second? Second. Senator Brown.
Yes, again, I mean, is there a concern?
Yes, Senator Brown, when we have a new governor in November of 2024, I believe the governor should be able to pick the person that they're choosing to serve most as any other appointed office. We serve at the privilege of the governor. So I believe this should be no different.
So is this because it doesn't look like a comma, so is this no longer 4-year term?
It's still,
It looks like,
It's a 4-year term, but can be removed. So if the governor doesn't do anything, it goes for 4 years.
so it's a max of 4 years.
it's a 4-year. He can be reappointed for 4, or she can be reappointed for 4 years, but at the end of the day, they serve at the privilege of the governor. Senator Glick.
Why have both in there? Why not say they serve at the pleasure of the governor and just eliminate the 4-year term?
Happy to, maybe if you want that, I'm
Because
happy to do it on second reading.
You're
but-
making it contradictory here. You're saying it's a 4-year term, but they can be removed. They're just, everyone else that's appointed by the governor is just appointed by the governor.
Access counselor.
Andy, can you do this on the fly? I don't like doing amendments on the fly, but can you make it just strike the 4 years and make it they serve at the pleasure of the governor?
Yes,
So tell the committee how it would read.
sure. On, looking on the amendment, line 4 would say the governor shall appoint a public access counselor, period. We would strike for a term of, shall appoint a public access counselor, strike for a term of 4 years. Keep at a salary to be fixed by the governor. The rest of it reads the same. So we are just striking on line 4 for a term of 4 years.
So with the permission of the committee, the governor shall appoint a public access counselor at a salary to be fixed by the governor, period. The public access counselor shall serve at the pleasure of the governor, period. Is there a motion to amend the amendment?
Second.
Can we take the motion to amend the amendment by consent? Okay, now, is there a motion to move the amended amendment number 4?
So moved. Second.
Can we take it by consent? Consent. All right. So now let's do amendment number 3. Amendment number 3 is helping a friend from the northeast part of, well, for me anyway, Senator Baldwin. The amendment says that provides that official action for purposes of the open door law includes receiving information, but only if the information is received directly by a governing body with authority to take final action on the public business about which the information is received. Senator Baldwin, would you like to briefly tell us where this comes from and what the issue you're trying to address is in amendment number 3?
Just kind of provide some direction on the speed of government. You know, there's been some opinion as to what constitutes a quorum and what can be done if, say, two county commissioners are having lunch with somebody receiving information but not formed to act. There's been opinion suggesting that that should be considered a public meeting with public access and everything else. And that's just not how things operate out there. People need to be able to receive information on the fly without forming a quorum and having a public action. That's as simple as that.
Is there questions about amendment number 3? Senator Brown.
So in other words, so this is saying so let's say I'm having a discussion about, I don't know, a possible tax abatement in my community or something like that, or where the TIF district should go. I don't know. And decisions that city council votes on. And so unless the whole body receives it while they're in session where they can have authority to act, is that what this is saying?
Generally, yes.
So if the information is received directly so I'm the city council person, and I don't have authority to act, to vote, unless I'm actually at the city council meeting on Tuesdays in Fort Wayne.
That's been noticed up and set in accordance with those laws, and the public's been noticed, and that's what the intent of the meeting is.
So the concern is we're doing it very specifically because
We don't want it to be construed that 2 commissioners out of 3 having lunch with somebody to receive information should be considered a public meeting. Or city council members or county council members, regardless of city, what is an official action? Can they
Well,
receive
actually-
information, just receive information and not make decisions? Can they be more flexible? That's kind of the speed of business these
Okay,
days.
I get that, but this was never a city council issue. But as I remember my commissioners, and this is beyond me, it seemed like there were times when, well, actually, I do remember. I was asked to mediate unofficially an issue on a stormwater district or something. I was part of it, and we couldn't have everybody there for this meeting because otherwise it was going to cause a problem with open door, et cetera, because it was supposed to be an informal discussion, like what are the problems? So there was no legal authority there, but as I recall, either members of the wastewater district and or commissioners, they couldn't all be there because they were following these open door public access rules. So I don't know if this is, I know what you're trying to do. You can just have a conversation like you said or a lunch, but I think there are more things, and maybe it's just a local level with commissioners, for example, but that was an interesting conundrum because we couldn't Zoom them in because then they would have been part of the meeting. So one of them had to physically not be present or involved in order to be able to have an informal conversation. So we followed the law. But now they could have that, and everybody who had a vote could have been in the room and could have
Received
sense,
information.
but they were kind of trying to figure out how to make a decision in order to actually then take action and make the decision. But they followed
weren't.
the rules.
But they weren't taking action that day.
But the difference is they followed the rules, Senator Baldwin. They followed the rules and said, okay, we're not going to have this official meeting and have all the decision makers there to make the. So I have a problem with this.
Senator Brown, yeah, I think just to try to answer your question, I think you're making my point on amendment number 7 and why I think it's needed. I think we all have meetings and we all have discussions, and those are good and necessary things. They're always not public meetings, and the public access counselor, I think, has gone way beyond the point of what the public access counselor should be doing and calling into question when a commissioner or 2 commissioners are having a lunch. And whether that's a public meeting or not, there's unintended consequences of when people act in these ways. And hopefully the public access counselor's watching. Senator Glick.
What is purpose of an open door policy?
Make sure the public has access to information about official actions.
Okay, so why would we let commissioners or council members or members of public bodies meet in private, discuss the issues? Because I think this smacks of coming back and then voting on something, but not in the public eye, not allowing the discussion. You know, basically the reason for open door was allow the discussion to happen, the information to come forward so that it can be contradicted by individuals in the course of discussion, and then take a vote so that it's all done so that people can see how their government works and how it functions. What you're doing here is you're gutting open door. You're saying they can meet someplace else, some other time, and then come together and take their vote. You've complied with the idea of, oh, we're having a public meeting, quote unquote. But in essence, they've had the meeting beforehand, they've made the decision, then they just come and go through the motions, and then they vote.
I suppose if we were to have concern with that, later today, the Democrat caucus and the Republican caucus here should not vote or should not meet and receive information or discuss things that are not public.
There's
You know,
serious question in this building about that.
There
Has been
is. But
for
I think
years.
the problem, if I may, Mr. Chairman, the problem is that, you know, just trying to be fluid and get things done when you got three commissioners and they run into somebody at lunch, two of them are having, or even one's having lunch, and they're not formed to take action. That lunch is not been scheduled to take action. And people are arguing that whatever's discussed at that lunch table is now subject to public discord. And that's the concern. It's just not the way the world works out there. We nobody is saying that anybody was convened at lunch at Applebee's when they ran into a constituent who brought information to them when they weren't convened for the sole purpose of taking action, that should be considered, public domain. That's the concern with this.
Senator Taylor.
Thank you, Mr. Chairman. I don't know if I even agree with your premise, Senator Baldwin. And here's the reason why. Are you saying that, okay, so let's say you got county commissioners and two of them over at lunch, and I've got a proposal in front of them for a zoning variance. And I'm like, hey, guys, I saw you were here, and I just picked up these pictures from the engineer. Here you go. You're saying that shouldn't be accessible by the public?
I'm not saying that.
Okay, what are you saying?
I'm not saying that wouldn't ultimately come into play if there's an official action at a later date.
But that meeting's not for an action.
You're talking about pictures that are handed to somebody. I doubt that's what we're talking about.
Oh, okay. So what are you talking about? Okay.
It's a conversation. Somebody approaches you at lunch and you're a commissioner or a council member and there's enough of you that might constitute a quorum,
right.
but you're not sitting there to have a meeting to take official action. Should that be considered something we need to record and put on the evening news? I don't think so.
Well, here's a question for you then why shouldn't it?
Why should they what?
Why shouldn't it be?
I'm missing your question. I apologize.
All right. I guess I'm kind of for as far as open door policy, shouldn't we actually be more stringent than loose because of the fact that you can manipulate a situation? So what I'm saying is, if I'm sitting there and me and my county commissioners, there's two of us, and there's only three in the county, and we're sitting there having lunch, and somebody walks up to us and doesn't just say, hello, how you doing? They say, hey, can't wait to see you next week at the meeting, zoning meeting. You're saying that shouldn't be considered open door?
Yes, that's what I'm saying.
What's the harm in that being open door?
I'm not sure how that can even be feasible out there with with all of the interactions. I don't know if you can walk through your district, Senator, without running into someone that you know and discussing something with them.
No. That's different. Maybe I'm not making it clear. I don't think the law allows us to get information about a meeting between two people because of who they are. I think it's based on what they discuss. Do you agree? I mean,
I don't disagree with that statement.
so how does this fix that though? Doesn't it actually err on the other side? So now let me just give you the hypothetical. Now, instead of having an official business meeting, we're all going to meet at the Applebee's and you give me the information and I don't have to tell anybody about the meeting. Can you do that?
Well, right now you cannot.
Right.
Not
but
if there's
can
a
you do that?
quorum.
But can
and
you do that if your bill passes?
You would be able to meet
Right.
with a quorum present, so long as you're not taking official action.
To discuss the action?
Just like the caucus you're getting ready to walk into.
Well, this is totally different. That's totally different. Okay. All right.
All right. Just so everybody's clear, I got 3 people signed up to testify, 2 in support, 1 opposed, and we are in caucus at 12:30. And we have to do this today or we were coming back after session. So, Senator Bohacz.
As the non-attorney in the room and probably the only one that was a county commissioner, this stuff does happen. But when I was commissioner, I would step away if somebody was going to make a presentation. There's an ability to do that. It's called a workshop if you don't want to take official action and vote on something. This gives me pause because we know that this happens anyway. But if you uncork it and make it a statutory course of action, it gives me some concern. So,
Senator Bohacz, what we're proposing to do is under official action as it is currently defined. It is currently, official action means to either receive information, deliberate, make recommendations, establish policy, make decisions, or take final action. There's other things that are defined in the code. What Senator Baldwin seeks to do is eliminate the receive information piece so that we don't have, in some ways, the absurd result that's come from the public access counselor saying 2 commissioners are having lunch. They're at lunch. Somebody sits down with them and says, hey, here's information for next week. Somebody has turned that into now that's a public meeting. Well, it wasn't advertised, wasn't publicized, it's not a public meeting. It's no different than all of us are going to leave this meeting. We're going to walk upstairs and any number of lobbyists is going to get us and start talking to us about some issue that we're going to talk about at 1:30.
it's actually a little bit different than that because you're saying that a constituent comes up and complains about their garbage not being picked up. That's very different than potentially a vendor making a pitch to 2 commissioners at lunch, because there's no differentiation between the two. So, and I, as former county commissioner, that stuff would try to happen. I would step away. So, because there's a time and a place for that. So I know what Senator Ball's trying to do, and it does alleviate some of the casual contact, but unfortunately it can be expanded into a lot more than that.
Well, I mean, the bill doesn't, if I may, Mr. Chairman, the amendment doesn't permit deliberation. It's just, if you read it, it's just receiving information.
I appreciate that, but receiving information could be a very big presentation. So.
Fair point.
All right. What's the will of the committee? It's been, is there a motion on the amendment number 3? Move the amendment. Is there a second?
I'll second.
Can we take it by consent?
No.
Okay. Andy, call the roll.
Point of order, Mr. Chairman.
Senator Taylor,
If you
turn your microphone on, please.
if you take this vote, does this kill the language? Is it the
I'll tell you in a minute.
If you maybe you didn't hear my question. Does this kill the language if it's defeated? Is it decisively defeated?
Probably yes.
Okay, right.
Well, Senator Taylor, the bill's not defeated. So the only thing
I didn't say the bill was defeated.
Senator Taylor, let me answer the question. You ask a question. Let me give you the answer. My understanding of the rules are if a bill is defeated, then that language is decisively defeated. If you kill an amendment, I don't believe the language is decisively defeated.
Okay.
I mean, it could. I mean, whether that can come up on second reading and whether that is good policy, I don't know. But
Senator Pohl.
Briefly explain my vote. Senator Baldwin, why I understand the idea of, you get a couple council members, board members, they get together, they want to have a conversation about something. They're friends. They're having an innocent conversation, and you get somebody that comes up, incidental, you don't want to be rude. I get that. But I think that the language as proposed goes too far in that, as to Senator Bohacek's point. I mean, we know that there's been instances where this occurs, and we're essentially establishing that policy then that it's okay to do this. I mean, I can tell you back in the day, growing up in the neighborhood that I was at, you knew where certain people were hanging out at certain times. And if you wanted to access them, you could go and find them at, the Indiana Cafe. But that, to me, I think by putting this into a statute and, essentially exempting that, I think that does lead to what we've kind of pushed against for a number of years, which is transparency. So I've got to vote no.
Senator Taylor.
No.
Senator Glick.
No.
Senator Cook. Senator Bohacek.
No.
Senator Brown.
No.
Senator Young. Senator Carrasco.
Explain my vote. I vote aye because being subject to this for many, many, many years of my career, the practical reality of these types of situations coming up is very real. And I always struggled to figure out what that fine balance is. I vote yes with a suggestion to maybe tweak to make sure that it doesn't go too far to address some of the concerns that were brought up during this hearing.
Senator Freeman.
chair votes aye.
Fails 3-5.
Fails 3-5. Amendment number 5. So the bill is drafted probably is a little liberal in its language. Amendment number 5 seems to streamline that in accordance with Smithley versus State, a 1991 Court of Appeals decision. The amendment would say that a presiding member may direct a law enforcement officer to move an attendee after issuing warnings for a violation of the rules or policies governing conduct at a meeting. And then there is a distinction between basically a locked door or an area that is marked as only authorized personnel only. There's a distinction in that case that Mr. Hedges drafted to try to thread the needle between that. So to tighten up the bill a little bit and make it clear that, you can't just remove anybody for any reason. And there's a distinction between something being marked and something being locked. So is there discussion about amendment number 5? Is there a second? Can we take it by consent? All right. We have an amended bill. Zach Stock, you're opposed. If you could be very quick, we've got 16 minutes. So tell us why you're opposed and introduce yourself if you would.
I like a challenge. Thank you, Mr. Chairman, members of the committee. My name is Zach Stock. I'm here on behalf of the Indiana Public Defender Council. We are opposed to 1338. We want to make 3 points. First, the language, this relates to a point Senator Bohacek raised, maybe a few others. The language was not heard in Courts and Criminal Law Committee in the House. That's not this committee's fault, but we think you'll agree that it's the best practice for committees dedicated to criminal law policy to be making criminal law policy. And I think as a result, you're going to see that there's a conflict you got to work out. Second, and perhaps relatedly, we're concerned about the criminalization of bare entry into an area, quote, otherwise not accessible to the public without permission. That's lines 11 and 12 of amendment that you just took. We've got no problem with the language about locked areas, but we think that the statute's creating perhaps inadvertently a crime with the potential for disparate enforcement. And let me just give you an example. In this building, in fact, this very room is a good example. Behind me, as you all know, and to the left is a private office of a Senate staffer. Around the corner, there's a whole suite of offices that are the private offices of Senate staffers. they are not accessible to the public without permission. I think reasonable people would agree. However, they are often open and they are very adjacent to a public space like this committee room. People aren't familiar with the building, can wander in them. They do wander into them. And we think a simple tweak, and we've provided the committee attorney here with that language, would ensure that that wandering is not a criminal act. And finally, as a body that represents lawyers who need to make public records requests, IPDC believes that the amendment number 6, or was it 7, 6 or 7, will have a detrimental effect on access to public records. We know the chairman's preference for textualism, but we think the amendment creates a type of hyperliteralism that will make the public access counselor's job very difficult, if not impossible. I would just point out a couple of things about the amendment. We would argue under the amendment that the public access counselor won't even be able to consult a dictionary, which is a fundamental component of any textualist judge's arsenal in statutory interpretation. And we're a little concerned that the parties to these disputes are going to focus on what is a valid opinion of the Indiana Court of Appeals or Supreme Court. Do we mean published opinion, or do we mean an opinion we don't agree with? What do we mean there? So the last thing I'd say is, and I think Representative Prescott mentioned this in the opening so many minutes ago, that the public access counselor's opinions are not binding on anyone. The Court of Appeals has said that on multiple occasions, that they're going to follow their own course. So if people don't like the public access counselor's opinions, they can go to court. And in fact, they can skip the public access counselor altogether if they want to. So with that, I'm happy to answer any questions.
Questions for Zach? Seeing none. Thank you. Jenna Bentley. Jenna, come on up. Tell us who you are and who you represent. Welcome to Courts and Corrections Criminal Code.
New here. Thank you, Mr. Chairman and members of the committee. My name is Jenna Bentley, and I'm here on behalf of AIM, representing Indiana cities and towns. Just want to offer our support to the underlying bill, House Bill 1338, specifically Section 2, to address issues with individuals entering restricted areas and municipal buildings and refusing to leave. This has been an issue for our members across the state, and so clarity in giving law enforcement the protections they need to enforce that is super helpful to our members. So with that, I'm happy to answer any questions, and thank you for your time.
Questions for Jenna? Senator Brown.
Thank you very much for your testimony. Have your members discussed this open door issue?
The amendment number 3, that was just no.
And so have you ever heard your members having a concern about being able to comply?
I would want to check in with our team. I hadn't even read the language of amendment number 3 before today, so I'm not sure what's driving it. Would want to talk to Senator Baldwin and our members.
So do you think that you would have, oh, never mind.
Sorry, I just didn't read the amendment before today.
It's all good. Senator Polk.
Jenna, thank you for coming to testify. Do you have legal staff with your organization, correct?
We do, yes.
You guys do trainings?
Yes.
Would your legal staff be able to, kind of look at different case law that's currently out there as it pertains to disorderly conduct, things that the underlying bill is ultimately trying to address as far as disruptive acts during a meeting? Would they be able to do some sort of training on that?
Yeah, we'd be happy to. I think we do often trainings on the open door law, and then so adding in the statute with the meetings and decorum. We've done some conversations on best practices when what these First Amendment auditors show up and how to react to them. So I think this would be kind of a part 2 to those conversations that are already happening. Yes, we would want to make sure they're complying. And
but as of right now, there's no statutory requirement that they actually take those trainings. So, I mean, you could have members out there that could be requesting law enforcement, since the members of the presiding officer is the one that's going to be making the determination, they could be having somebody arrested without having any idea what the definition of disruptive behavior is as of stands right now if this bill were to pass, correct?
So to your original question, no, they are not required to attend our trainings, but I do think law enforcement is going to be careful on who they arrest as well. And this just gives them clear, like, here's the decorum, you're violating that. I think at the end of the day, the issue we're trying to get at is when it's so disruptive, you can't even hear the members speaking, right? And I think Section 1 just codifies existing practice. They can already say you can't speak at a meeting unless it's a public hearing. So I don't think this is doing anything new, but giving law enforcement kind of the backup they need to say, do we need to act here or not?
Okay, thank you.
Any other questions? Seeing none. Ryan Hoff. Ryan, tell us who you are and who you represent.
Thank you, Mr. Chairman. Good morning, good afternoon to the members of the committee. Ryan Hoff, representing the Association of Indiana Counties. We rise in support for a lot of the same reasons that Jenna just mentioned. We've done a lot of training with our members, best practices and so forth on how to handle these situations and interactions. But having clear law will go a long way to support these efforts, not only in terms of the public decorum piece, but also the First Amendment auditors piece about establishing non-access areas. So urge your adoption. Thank you very much.
Questions for Ryan? Senator Brown. Sorry,
Thank you very
Senator Brown.
much. So again, do you have any questions or have your commissioners have concerns about open door?
Anecdotally, I've heard some of our members talking about situations for, I'll just use one as an example of something I've come across in my work. Working with the State Department of Agriculture, they're setting up workshops for kind of this is how a solar farm works, and inviting members of county officials to come and observe, an explanation about this is what a development looks like and so forth. And we had members say, well, only one of the three of us can go because that's receiving information. It would have to be posted as a public meeting and so forth. So again,
And was it a
anecdotally,
public meeting? Was the workshop a public meeting?
so in that case, only one of them went.
But was the workshop itself a public meeting?
It was
Was it
invite-
open to the public?
No.
So
But-
do you think that this open door is okay, that they should be allowed to have that kind of access and no one knows about it?
So I think our members, again, anecdotally, because we haven't
Mm-hmm.
formed a position on this formally, anecdotally would say receiving information is probably too broad, and identifying, again, the sweet spot that a few people have mentioned would certainly be helpful.
Because the way this reads, only when the commissioners have their commissioners meeting.
It would have to be publicly noticed. I don't know if you'd call it an emergency meeting just because it's not part of the regular schedule, but again, there may
You go
be
from one extreme to the other.
Right.
Any other questions? Seeing none. Representative Prescott, I'm sorry for your length today. Obviously, there probably needs to be a second reading amendment to clean some of this up, right? And would you like to close?
I'll wait to close due to time.
All right. Is there committee discussion on 1338 as amended? Seeing none, I move the bill as amended. Is there a second? Andy, call the roll.
Senator Pohl.
Briefly explain my vote. Just the amendment that went in pertaining to public access, Counselor, caused me some concern. If this, the bill does get through, I'd like to work with Representative Prescott on potentially requiring some sort of training for the members pertaining specifically to disruptive behavior. I mean, what I don't want to happen is, we have all kinds of First Amendment lawsuits that we start getting hit with because, armed with a new way of removing, opposition out of a meeting. You've got members that kind of, tensions are high. Believe me, my wife is a school board member. She's been screamed at over the last couple of years, multiple times in meetings. I'm sure she would love, the ability to, be able to demonstrate, hey, there's an enforcement mechanism to this. But, personally, I think that there definitely needs to be some guardrails and some required training, just as anybody else with the authority to, to take a specific action against somebody's liberties are provided with. So with that, I have to vote no just on this bill.
Senator Taylor.
Yes.
Senator Glick.
explain my vote. I have some concerns about parts of the bill, but I like some of the measures that are in it, so I'm willing to work with the author and the chair on kind of tweaking the bill. With that, I vote aye.
Senator Cook.
Aye.
Senator Bohacek.
Yes.
Senator Brown.
No.
Senator Young. Senator Carrasco. Senator Freeman.
Chair votes aye.
5-2.
Passes 5-2. Thank you all again for the year, and we'll work on it for second reading. Senator Ball.